concludes that it would be unconstitutional to grant an order of unsuspended committal in the context of motion proceedings if the committal is not aimed at coercing compliance with a court order. The minority's judgment agrees wholeheartedly that this court must defend its orders and authority, but stresses that it can only do so within the bounds of the Constitution. It warns that while satisfying an undesirable desire to address Mr. Zuma's scandalous disrespect for this court, an order of unsuspended committal would trample over the constitutional rights of alleged contemners, including Mr. Zuma. After surveying our jurisprudence on civil contempt, the minority judgment concludes the following. First, that civil contempt has dual remedial and punitive processes, with the main process of civil contempt proceedings being the enforcement of the court order, and that it had found no case in the history of our jurisprudence in which a punitive committal order had been ordered. Secondly, that the Constitutional Court had yet to consider the constitutionality of punitive committal orders in the context of civil contempt proceedings, but has concluded in respect of criminal contempt of scandalizing the court that a summary contempt procedure intended purely for penal purposes is inconsistent with the fundamental rights protected by Section 12 and 35 subsection 3 of the Constitution, because there is no interference in the judicial process or the administration of justice, which calls for swift remedial action. The minority judgments note that it is not enough to say, as the majority judgment does, that the contemner allows punitive committal to be ordered in civil contempt proceedings. The Constitution is the supreme law of this country, and the common law is only instructive to the extent that it is constitutional. The minority judgment has therefore considered whether a common law rule allowing a civil court to order a punitive sanction of committal with no pet remedial purpose constitute a justifiable limitation of the right to freedom and security of the person and an accused's rights to effect trial. The minority judgment concludes that depriving a contemner of liberty without a criminal trial limits Section 12 of the Constitution. While acknowledging that an alleged contemner in the context of civil contempt proceedings is not an accused person for the purposes of Section 35, subsection 3, it concludes that Section 35, subsection 3 remains relevant because had the contempt been adjudicated in criminal proceedings, the alleged contemner would have enjoyed the protections of Section 35, subsection 3. In this regard, the minority judgment identifies a host of respects in which civil contempt procedure falls short of the protections enshrined in Section 35, subsection 3. First, although civil contempt proceedings are a hybrid of civil and criminal elements and therefore must be conducted in a manner which is grounded in Section 12 and Section 35.3 of the Constitution, the adaptation of motion proceedings to reflect the hybrid status depends on a judicial officer's assessment of what seems fair in the circumstances. By contrast, the procedural rights in Section 35, subsection 3 are peremptory. Secondly, civil contempt proceedings, especially when brought on an urgent basis, as in this case, limit the right to have adequate time to prepare a defense as enshrined in Section 35, subsection 3b. Thirdly, the consequence of granting direct access in this matter is that the majority judgment's committal order is unappealable, which limits Section 35.3.0 of the Constitution. Fourthly, the motion procedure limits the alleged contemner's fundamental right to remain silent and to be presumed innocent to the extent that it requires the alleged contemner to present a defense before the initiating party has made out a prima facie case against her or him. The minority judgment concludes that these deficiencies amounted to serious violation of constitutional rights when one has regard to the fact that Section 12 and Section 35 subsection 3 protect a profound and essential right to freedom, which is the bedrock of our constitutional order. It concludes that in an open and democratic society based on human dignity, equality, and freedom, litigants are not prosecuted criminally in civil court by their adversaries in circumstances where they are not afforded an opportunity to cure their contempt in order to avoid being deprived of their liberty. Although a contemner faces a deprivation of liberty without a criminal trial, when the committal order sought is coercive, as well as when it is punitive and unsuspended, the minority judgment explains that the limitation of rights inherent in civil contempt procedure becomes unreasonable and justifiable and unjustifiable when punitive committal is ordered for two reasons. The first is that while civil contempt proceedings serve the legitimate purpose of providing successful litigants with a speedy and effective means of enforcing court orders, when the relief sought is singularly punitive and not linked to enforcement, this justification for limiting rights falls away. The second is that the limitation of rights is substantially tempered when the contemner can avoid imprisonment by complying with the court order. The minority judgment holds further that granting punitive court orders against contemners also serve the important constitutional purpose of defending judicial authority and upholding the rule of law. But it notes that the rule of law is undermined when judicial authority is protected at all costs. It warns that in this case, when determining the weight that should be accorded to the rule of law and enhancing functions served by the limitations identified above, one must assess the threat to the rule of law posed by Mr. Zuma's civil contempt and not his inflammatory statements. This is because, as the Commission and the Helen Suzman Foundation accept, Mr. Zuma's remarks arguably amount to the crime of scandalizing the court, which is a separate species of contempt. Neither the Commission nor the Helen Suzman Foundation has asked this court to punish Mr. Zuma for this separate contempt, and it is inappropriate to bolster the justification for granting the relief in motion proceedings involving civil contempt by pointing to the threat posed to the Commission of a separate offense altogether. In any event, the minority judgment emphasizes that constitutionality is determined objectively, and it would be a mistake to fixate on Mr. Zuma's conduct in particular. For these reasons, the minority judgment concluded that it is unconstitutional to grant a punitive committal order with no paid remedial relief in the context of civil contempt proceedings. The minority judgment laments the invidious position the Constitutional Court has been placed in by the Commission. Although the Commission sought Mr. Zuma's attendance in 2018 already, it only drew the Constitutional Court into the arena by launching an urgent application in late December 2020. Instead of pressing criminal charges against Mr. Zuma for contempt of court of the Commissions Act, which it had previously threatened to do, it compelled the Constitutional Court to solve a problem born of the Commission's overly different approach to Mr. Zuma. Though the substratum of its dispute with Mr. Zuma was non-compliance with the Commissions Act, the Commission has effectively sought to transform that dispute into one between Mr. Zuma and the Constitutional Court. The minority judgments mention all of this to demonstrate that the choice between holding Mr. Zuma accountable and protecting his constitutional rights is a false choice. It is open to the Commission to refer Mr. Zuma's contempt of this court's order and the Commission's Act to the Director of Public Prosecutions. The minority agreement agrees that Mr. Zuma's contempt exposes him to an order of committal, but concludes that the constitutionally compliant approach would be either to make an order of coercive committal aimed at inducing Mr. Zuma to comply with this court's order if the Commission's term has not come to an end by the time judgment was handed down, or an order referring the matter to the Director of Public Prosecution for a decision on whether to prosecute Mr. Zuma for contempt of court. In the final analysis, the Constitutional Court makes the following order. 1. The application for direct access is granted. 2. The Helen Suzman Foundation is admitted as amicus curiae. 3. It is declared that Mr. Jacob Gedleyihlekisa Zuma is guilty of the crime of contempt of court for failure to comply with the order made by this court in Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, versus Jacob Gedleyihlekisa Zuma. Mr. Jacob 4. Mr. Jacob Gedleyihlekisa Zuma is sentenced to undergo 15 months imprisonment. 5. Mr. Jacob Gedleyihlekisa Zuma is ordered to submit himself to the South African Police at Nkandla Police Station or Johannesburg Central Police Station within 5 calendar days from the date of this order for the station commander or other officer in charge of that police station to ensure that he is immediately delivered to a correctional center to commence serving the sentence imposed in paragraph 4. 6. In the event that Mr. Jacob Gedleyihlekisa Zuma does not submit himself to the South African Police Service as required by paragraph 5, the Minister of Police and the National Commissioner of the South African Police Service must, within 3 calendar days of the expiry of the period stipulated in paragraph 5, take all steps that are necessary and permissible in law to ensure that Mr. Jacob Gedleyihlekisa Zuma is delivered to a correctional center in order to commence serving the sentence imposed in paragraph 4. Mr. Jacob Gedleyihlekisa Zuma is ordered to pay the cost of the Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, including the cost of 2 counsel on an attorney and client scale. I hand down the judgment.
As the court pleases.
You've just witnessed one of the biggest moments in our country's constitutional democracy. A former president, Jacob Zuma, who's 79 years old, has been sentenced to direct imprisonment of 15 months for contempt of court. He has 5 days to present himself to a police station at Nkandla or in Johannesburg to be sent to a correctional facility. He will appear in court on his fraud and corruption trial on the 19th of July. He has also been ordered to pay the costs of 2 counsel. If he does not present himself to a police station in 5 days' time, the Minister of Police has been ordered to do whatever is necessary to make sure that he does. In one of the strongest worded statements that the Constitutional Court in this country has ever delivered, it sought to uphold itself as the guardians of the Constitution and said that Jacob Zuma's behavior to choose some words, has been contemptuous, outlandish, scandalous, egregious, vexatious, and smacking of malice. Strong words there, asserting its power as custodians of the Constitution. It was a judgment of 7-2 to the majority. We now go to Jacob Zuma's spokesperson, Mzwaneli Mani, who's standing by for us. Mr. Mani, your reaction, please.
Good afternoon, and good afternoon to all your listeners. Today is a sad day. We've just listened to this judgment. It's sad because, firstly, I think as a foundation, we note that the judgment was not unanimous.
But
it's very fundamental.
7-2.
Judgment is not unanimous.
Which is not
As
unanimous.
a foundation,
7-2.
we've just listened and heard.
And we are not in a
very
jury.
cogent argument from the minority
We don't need
judges.
unanimous
And
in
we
South Africa.
also heard that the minority judgment is saying this ruling is actually unconstitutional. And this is said by people that are not politicians. So if judges say this judgment is unconstitutional, it creates a crisis, actually, in terms of implementation of this unconstitutional judgment as pronounced by other judges. This is not the foundation saying this. If you've got competent judges, sober judges that are saying this judgment is unconstitutional, how do you expect us as a foundation to say to our patron that he must accept the rule of law if the people that are entrusted with the rule of law are saying this judgment is unconstitutional? So indeed, we will study the judgment. Our lawyers will study this judgment, and a much more comprehensive statement will be issued in due course. But as things stand right now, we are very persuaded by what Justice Justa and Justice Taron have said. We think what they've said. They've quoted the Constitution. They've quoted the circumstances, and instead, in response, the majority judgment seems to be based on the riding on the issue of their opinion, so to speak. When the other judges are arguing a matter of law, that in terms of the law, this is how it should be dealt with. But the other judges, they seem so hurtful with President Zuma. They're just not going to have none of this nonsense, and they're going to just go ahead and use their majority to make a particular ruling. We think the minority judges actually are being the lawful officers in this case that are not emotional. We reading from the judgment, it would appear that the majority judges are quite emotional on this issue, and so on. So we study the judgment and we'll issue a full statement.
Mr. Mani, where is the former president, and is he going to, at the age of 79, argue that he is not in good enough health to be sent to jail?
Yeah, well, firstly, to be saying where President Zuma is a security issue. I'm not at liberty to disclose his exact whereabouts, as it were. That's the first thing. And as to how his attitude is going to be out of this, it's a matter that will be shared in due course. At this point, I'm sure he is very shocked to see that we have officers of the court that are saying the judgment is unconstitutional. But this judgment goes ahead, despite advice by judges that this is a travesty of justice. So indeed, he must be shocked where he is that for all these years that we've been fighting for justice in this country, for all these years that we've been fighting for constitutional democracy, but we've got constitutional democracy that is implemented in a manner that is dependent on opinions of judges as opposed to the law. And these are the words, basically, of the other judges, as it were. So anybody sitting and watching this is saying, wow, what is going on in South Africa. Why is it that we have judges that are saying, hello, colleagues, this is unconstitutional, but the other colleagues are not phased. They're not hurtful. They just want to do this. It's regardless of the consequences. So it's a sad day in South Africa.
Mr. Mani, Justice Kampepe was very clear that this punitive sentence is very much about sending a strong message that nobody is above the law. The MK vets outside in Kandla have said for the past 4 months that they will not allow anybody to take the former president from his residence. Do you see any kind of unrest or problems occurring at the residence or wherever the president is currently situated?
No, I think that comment is inviting something that would later be interpreted as me inciting violence, as it is. So I'm not going to respond to that comment, but we'll just see what's going to happen in the country. But I think I must say that, you see, that kind of a thing is what Justice Kampepe also said in her judgment. She said that as the court, they've got to be impervious to these things. So let's see what that is the full expression of being impervious means, as it were. But I sit here and I'm saying, as the foundation, we think it's a sad day today. We think it's a sad day largely because judges are saying the judgment is unconstitutional. If we had a unanimous judgment today, I'm almost sure the foundation will be issuing a statement to say justice has prevailed and therefore President Zuma must subject himself to processes and all of that. But if you have
that's a jury.
That are saying
We don't have a
this
jury.
judgment is unconstitutional, what do you expect should be the attitude of President Zuma when judges themselves are saying, of the highest court in the land, are saying the judgment is unconstitutional? That's what we're
It's
sitting
just
with. I think we're sitting
seven
with a
against
dilemma in
two.
this country of a judgment that must be implemented, but judges are saying that judgment is unconstitutional. I think we have a crisis.
Mr. Mani, a 7-2 dissent is pretty common. In fact, it's noted most of the time. When you say there's a crisis, what do you mean by that? And let me remind you, please, that Mr. Zuma himself told the Constitutional Court that he was willing to go to jail rather than testify.
I think we have a crisis when we have the people that are entrusted with protecting and defending South Africa's constitution, people that are entrusted with defending the rights of individuals as enshrined in the constitution. Now, if those people are saying if those people are saying what should be happening now is we should have a judgment that is coercive, as it were, so that a person must actually hang himself, if you like, as it were. Now, if they are saying this is what should have happened, and they are saying to have a situation that you have now that is not even appealable, as it were, why do you do this? Why do you, when you like, treat a case as if it's a civil case? When you like, you treat the case as a criminal case. When you like, you take away the rights that accrue in a criminal case, and you say, therefore, this right does not apply to you, this does not apply to you. But when you like, you impose a sentence and you treat a person as a criminal, and yet all the rights that accrue to an accused, as in a criminal case, you've taken those away. What kind of inconsistency is this? This is really a crisis. How can you have judges that are cherry picking which side of the pie is sweeter? This is what you have.
Mr. Mani,
It's very shocking.
Mr. Mani, before I let you go, I'm sure that your phone's WhatsApp
Yes.
is going mad.
Yes.
Are you getting any reaction from Mr. Zuma's family or close associates? And if so, can you share those with us?
I think even if they wanted to phone, they wouldn't have had the chance to come through. I'm inundated with media. I've got to run now. and talk to other people. You've had the first cherry on the bite.
Thank you, sir.
Yeah, okay, so I've got to run. That is our position. We will issue a full statement in due course after I've spoken with the lawyers.
Good journalist.
Jacob
this man.
Zuma's spokesperson there, Mzwanele Manyi, speaking to us, saying he is shocked there is a constitutional crisis with the imprisonment, the direct imprisonment of Jacob Zuma of 15 months to jail for contempt of court. We have so much reaction coming in for you. Please stay tuned. We will be back after the break. This is it from Newslink. Thank you.